Let's talk about what is probate and what is a will. I think most people are really confused about this. Several times a year, maybe as much as 2 or 3 times a month, somebody will call us and say, my dad died, my mom died, my stepfather died, whatever the situation is, there's been a death in the family, and they just don't know, do we have to do probate? What do we have to do now? And so I'd like to explain probate to you and talk about kind of where it comes from and what purpose it serves today, which is different, I think, by far than when it was established and created. First of all, let's think about when it was created. Probate, the dealing with an estate in court with a probate judge in the old days or a district judge today, was to deal with almost any issue that came up relating to an individual's property and debts and any other issues at death. But it was designed at a time before we had automobiles. It was literally designed at a time when Native Americans roamed the plains, and I'm not joking about that. I'm just trying to say this is the kind of antiquated system it is. It's been addressed and updated over the years, but it's certainly a slow process, and it's easy for me to see how much of this was done at a time when life was much slower. Probate, formal probate, is a process of petitioning the court and asking permission to do various things, and you do that all the way through the probate. We don't see much really formal probate today, but if we had that, I like to describe it as a big game of Judge May I, just like the children's game Mother May I. You can't do much without getting the court's permission, and to get the court's permission, you have to file a written petition that's been verified by the person that's making the request, which means it has to be signed and notarized. And then the judge can't just say, okay, yes or no. The rules are that you typically have to notify everybody who has an interest in the estate, and that can be a lot of people, and you have to wait for time to go by to do that, often 10 to 30 days before you can get an answer on your petition or request to the court, because we have to allow time for everybody who has an interest in the estate to see what the request is and determine whether or not they want to consent or object. And we'll talk more about how some of those issues come up here in a minute. I'd like to also tell you that people are very concerned and confused about wills as to what they control and what they really are, and if somebody's named as executor, what authority they have. And very simply, a will is kind of like a letter to the court or to the judge saying, at my death, understanding there are certain rules about taxes that have to be paid and creditors that are entitled to be paid. But beyond that, then here's how I want my property distributed at my death. And that's typically what the will provides. But it only controls certain property, and the executor only has authority over the property that is properly in probate.
Yeah, and I think that's kind of an important distinction that I see so many clients get confused on. Probate property or probate assets would be an asset or an account that I have or that I own in my name and my name alone, with no other joint tenants, no beneficiaries, not in a living trust. So if I've got a checking account that's just titled in my name and I pass away, my wife, my children, my heirs, whoever the next closest in line to me would be, they will have to go through the probate process to get access to that account. So my wife can't just walk into the bank and say, well, here's a marriage license, here's a death certificate, I'm the spouse, give me the account. And by the same token, my spouse can't walk in and say, well, here, here is Logan's will. It names me as the executor. It names me as the beneficiary. Give me access. The bank or financial company is going to say, no, that's not good enough. You have to do the process that Tim described, which is take this will down to the courthouse, get it approved, go through all the hoops, hire the attorney, take care of all of those steps, and then once the court finally approves this and appoints an executor, that's when my heirs, my spouse, my children can get access to the accounts.
The court has to make a determination that, yes, in fact, this is the person who died, we call the decedent. This is the decedent's last will and testament, and it was properly executed with all of the formalities that are required under Kansas law, meaning that it's signed at the end thereof and with 2 witnesses. And that the person who was named as executor qualifies today to serve as executor and then are appointed by the court. So unless you have the court order that both admits the will to probate and appoints the executor, the will doesn't mean anything to anybody.
Yeah, that process just to go from death, having the attorney draft it, take it down to the courthouse, notify everyone, wait for the hearing, wait for the judge to make a decision. In most cases, the absolute fastest you can get it done is about 30 days. And oftentimes it's a little more than that. So that really can kind of hold up paying for final burial and funeral expenses. You know, dealing with if there's a mortgage on the house, you know, how do we keep these things going if we have to wait 30, 45 days before someone can even get access to the checking account?
Now, there are various ways to take care of things in that event. There's not just one way or one type of probate. First of all, with the accounts that Logan was talking about, often they're accounts that have far less than $40,000 in them. But we have a statute that says if we're dealing only with an asset, a personal property that has less than $40,000, such as an account, then we don't have to go to probate if we're able to do what's called a small estate affidavit. And an affidavit is a sworn statement, and in this case it's signed by the heirs of the person who died, stating that, yes, you know, Dad died and at that time he owned this account at this bank and it had $3,500 in it, and maybe there are 2 children and they say we are the heirs and we agree that this account should be paid out 1/2 to each of us. And it's kind of, in some ways and sometimes, like a miniature family agreement, but that is, a small estate affidavit is one way around having to do probate. But we've seen situations where everything transfers, say, to the surviving spouse. Say Dad has died, everything was in joint tenancy, or what wasn't has Mom as the death beneficiary, and so we look at it and say there isn't anything to do here, and then they'll say, well, Dad worked at Boeing, and Boeing for years had a stock program where you got so many shares of stock per pay period, and we just see these situations where, you know, well, Dad had 74 shares of Boeing stock and it's just in Dad's name because that's the way the program worked, and that stock is worth more than $40,000. Now we've got to come up with a way through probate to deal with it. And so we want to visit with you just a bit about the various types of probate. As I mentioned earlier, I talked about formal administration, which is literally where you have to make a petition or request for everything you do, all the way through to paying creditors and approving the accounting, and it's just a lengthy, slow process. But most of the time, if you see the publication notices for an estate in a newspaper, you'll see reference to the Kansas Simplified Estates Act. And the Simplified Estates Act provides for some simplification to that formal process. There are many things that can be done without having to ask the court's petition. There are still certain things, including wrapping up the estate, that that require the court's approval, but it is a simpler process, and so you can save some time in the process by doing what's called a simplified estate. But more than that, there are some other probate procedures that we use. When somebody comes in and we discover that there's something that's going to need a probate court order, there's some type of probate that's going to be needed, what I typically tell people is that let's figure out what's the simplest and least expensive way to solve this problem. And so beyond simplified estates, oftentimes we deal with real estate issues, and we're going to talk about joint tenancy and tenants in common here in a moment, but we'll find out that actually the person who died had an interest in the real estate that has to pass through probate. And this often comes up when somebody's made a sale, say a surviving spouse is downsizing, and they discover that, gosh, there needs to be probate for the deceased spouse's interest in the property, and we can do a determination of descent or request a decree of descent, and that's a fairly simplified process, but it can only be done if more than 6 months have passed from the date of death, and it's simply saying, yes, this person died on this date, they own this real estate, more than 6 months have passed since their date of death, and the property passes to their heirs. And let me talk about that for a moment. When you hear the word heirs, we're talking about the people who would inherit the property if there was no will. And that process is called intestacy. Dying intestate means dying without a will. And the only property it affects is the property we're talking about that would be subject to probate. But, if you're married, it goes to your spouse. If you're married and have children, the law of intestacy says your interest goes 1/2 to your spouse and 1/2 to your children. And we have many second marriages today where if we end up with having to deal with that process, we may find out that the husband's interest in the property is now owned 1/2 by his spouse and 1/2 by his children who are in Texas. And if we're trying to sell the property or liquidate it, we have to now get them involved to agree to sign off on the documents. And if possible, if the funds need to go to the spouse, they don't have to agree to that. They can say, no, I own my undivided whatever fraction, and I want my share of the net proceeds.
What Tim just described on the intestate process is what I kind of like to call the state of Kansas estate plan. Whether you've created a will, whether you haven't created a will, you have an estate plan in place. Long ago, when Tim was describing in the early days of our state, the folks up in Topeka created a plan for every Kansas resident that dies without a will. And those situations he was describing, if there's a spouse, if it's a second marriage, if it's a blended family, if there's a spouse and children, and all of a sudden you may get property that was intended to go one place, it may be split up among several different people. So quite simply, you creating your last will and testament is your way of opting out of the state of Kansas plan for you. You creating your will allows you to direct what happens, tell who gets what property, when they get it, who's in charge of administering or wrapping up your affairs. It's a really good, really easy way to maintain some control. And we find that a lot of our clients like to maintain the control as opposed to having it be decided later on by someone they've never met. The judge, the man or woman who's sitting behind the bench wearing the black robes, they'll follow the law, they'll make the best decisions they can, but they don't know you, they don't know your family, they don't know your children, they don't know what needs you have. So that's why we feel at a bare minimum, having the will or your set of instructions to the court is a key component of any estate plan.
Now, one of the reasons Logan just said that is that most people want to avoid probate. And so you say, well, why should I have a will if I want to avoid probate? Well, it's because there may be assets that you can't control that you are entitled to at your death, or that are just in your name at your death, that are then going to pass pursuant to Kansas law of intestacy if you don't have a will.